In the spirit of reconciliation, Law Squared acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today.
Hello and welcome to Retail Leasing Essentials presented by Law Squared. I'm your host, Annika Childs. I'm a commercial and project lawyer here at Law Squared, and I'm very excited to get stuck into this topic today with our panelists. So today we're going to dive into the crucial aspects required to navigate the life cycle of a retail lease. For those of you responsible for managing or negotiating retail leases, you'll know that these agreements form the backbone of any successful retail operation. So with the growth of e-commerce and the shift in customer expectations, getting the right lease terms, understanding the fine print, and aligning your leasing strategy with the business goals is more important than ever. So whether you're opening your first storefront, expanding into new markets, or simply refining your existing retail strategy, today's session aims to set you up with the practical knowledge and legal perspectives to confidently approach every phase of your retail lease. And to guide us in that discussion today, we have a very accomplished panel. So first, let me introduce Ben Kirkham. Ben was based in Singapore for over a decade, where he owned a project and construction management business working across projects throughout Southeast Asia. Notably, Ben managed the full life cycle of the global franchise Super Park as it expanded into Singapore, Bangkok, Kuala Lumpur, and Hong Kong. He was responsible for handling site selection, leasing, construction, and operations. Ben is currently CEO of Superpark's first ANZ indoor adventure park, located at High Point Shopping Centre in Melbourne, just down the road from me. Welcome, Ben. Really looking forward to hearing some of your personal experiences in this space.
Thanks, Annika. Great to be here.
Next, please welcome Jamie Rowland. Jamie is the Executive Director and Head of Retail Solutions at Franklin Shanks. She brings over 25 years experience ranging across F&B, fashion, FMCG, luxury, health and wellness. Jamie is passionate about the power the retail experience has to entertain, shape trends and provide human-to-human engagement. Jamie works with Franklin Shanks clients to put their customer experiences at the heart of their property strategy, bringing strong and agile property portfolios that support their operations, culture, brand and growth. Great to have you on board, Jamie. Definitely looking forward to some great retail strategy insights as well.
Thanks so much. It's very nice to be here.
And finally, a warm welcome to Law Squared's very own Sarah Ward. Sarah has over 17 years experience in property and infrastructure and is an accredited specialist with the Law Institute of Victoria in commercial tenancy law, which basically means she's an expert in leasing law. She loves being involved across legal project planning and management, document suite development and drafting and negotiating agreements that represent all types of interests in land, including leases, subleases and licenses. Sarah regularly acts for clients in the retail leasing space across Australia and New Zealand, including overseas companies entering the Australian market, and sits on the LIV's Property and Commercial Tenancy Law Advisory Committee. She's busy. Looking forward to a great discussion today with you all.
Me too. Looking forward to it.
Okay, so now before we leap in, a quick word on housekeeping. So by taking part in today's webcast, you're earning 1 CPD point. To help us optimize your valuable time today, we will take questions in the chat bar. I expect we'll cover many of the questions during our chat today, but we'll also collate these later after the webcast and send you a more detailed answer and resources in the coming days. So don't be shy. Please drop your questions in the sidebar and our chat moderator, Lisa, will make sure that we get back to you. Okay, let's dive into retail leasing. First up, let's talk about the life cycle of a lease. Sarah, do you want to start by telling our listeners what I mean by that?
Sure. So when you start thinking about retail leasing, there's a lot to it and a lot to think about. First thing is a lease can be for a really long time, which means your relationship with your landlord or your tenant can also be for a really long time. That's whether it's a good or a bad relationship. So I think it's really important to look at the big picture, break down the issues, and really be clear on what you want and when during a lease. To make thinking about all these things that might come up a little bit easier, I like to give the lease a bit of a life cycle and break it down into things to think about before you lease, during your lease, and at the end of your lease.
Makes sense. So even before you enter a lease, there are quite a few things we need to get right. One of the most important things is, of course, finding the right premises as a start. So, Ben, knowing that you've been through this exercise not so long ago with the opening of Australia's first super park location, do you have any personal experiences you'd be able to share about finding the right premises either here or in Asia for super park?
Yeah, I think Sarah's 100% right there. In regards to just our experience just in coming to the Australian market, obviously spent a long time in Southeast Asia, so had a fair understanding up there, but coming into Australia, totally different landscape. And we really put in a lot of time into demographics. So for us personally, it's mobile data, it's census data, it's we engage with consultants such as Retail Oasis, and really took our competitors and the market rates of pricing, etc., medium incomes. We really look at really specific data, so it's income, age brackets. What are people's patterns of how they spend their money? Entertainment. Some areas just aren't spending any money on entertainment, so you really do all that analysis. And across Australia for shopping malls, there really is only, let's call it a handful in each state you can actually touch that are going to be good for your business. Obviously, every business is different, but for us personally, spent a lot of time up front, and Sarah was there along for that journey, making sure we were doing everything we can to put the pin in the right spot.
That's so interesting. Jamie, you also work with all sorts of clients in the retail space. How important do you see that initial site finding task? And I suppose what sort of market knowledge would you want before settling on a site as well? I know Ben touched on some, but are there any more that you can let us know?
Yeah, I think you can't stress enough how important starting as early as possible is. Whether it's a new site or a renewal, time is your friend, and it can also be your enemy. So yeah, doing that early research and really understanding what the levers for success are for your business and how that aligns with a property. And I think something that people don't realise is how nuanced that can be in retail, depending on the different types of retail businesses. Right down to, I can remember once going and doing a site inspection with a client, and we got about 200 metres from the front of the street front store, and I said, no, we'll go because we'll go and be polite, but no. And he looked at me and he said, how can you tell from here? So there's a rubbish bin right outside the store. So it's creating a funnel point on the footpath, which means that people are going to pass through that faster, and they're going to be looking down, and they're not going to look in your shop front. Whereas if you had the site next door on either side, you'd be in a better position. So it's really understanding, that micro detail of what makes a site work, and whether or not that's right for your business. For different types of retail, whether you're relying on foot traffic, for impulse purchases, or whether you're a destinational retailer, it can be a completely different set of criteria.
Well, I guess for a legal perspective on this, important considerations, Sarah, let's turn to you. What are some things that people should be aware of before entering a lease? Do you have any advice for our viewers, from that legal standpoint?
Yeah, sure. And look, first of all, I agree with both what Ben and Jane was saying. Ben was an absolute pleasure to work with because he did actually have that data. He understood what he wanted. He had his non-negotiables. And I had the absolute pleasure of attending their opening day and, seeing the lease from start to finish, and his store opening and the specific things that he needed and the way he used his data to actually set out and fit out his store. So I suppose from a legal perspective, I'm going to harp on about that a lease is a contract. You're going to be legally bound to do certain things during the life of your lease, which I mentioned is going to be for a long time. So if I could pick a few things about a lease and what to do at the start, I'd say, look, be really clear what you want and need from your premises. You may even want to write down your non-negotiables so you don't end up somewhere that doesn't work for you. I think it's a good idea to be upfront about the terms that you will agree to. And if you have any of those big curly ones, that you put these out early and you discuss these early so they don't come as a big surprise to the other party later on. Next, don't sign anything until you have read and understood the deal. This actually happens a lot where someone will come to me with their one-pager that they've signed, which is legally binding. To give you a recent example, it's common that large landlords will include a line about agreeing to a landlord standard lease. This is even if you haven't seen the lease or had the opportunity to get advice on it. Please don't sign these things because you may lose the right to negotiate the terms of the lease later that are not included in that one pager heads of agreement or some other sort of deal. Lastly, we're here to talk about retail leasing, and I think it's really important that you understand early whether your lease is retail, because this will affect the rights and obligations of the tenant and the landlord and will affect how the lease is negotiated. For example, in Victoria, you might agree to pay land tax as part of your commercial deal. But if you have a retail lease in Victoria, the landlord's actually prohibited from on-charging land tax to the tenant, and that's whether or not the tenant has agreed to that as part of the deal. And an important thing to remember as well is that there's different retail legislation in each state and territory, so these rights and obligations might be different depending on where you're leasing.
Great. So in terms of due diligence, what do you think, I suppose, are the most important things for both a landlord and a tenant to do before signing a lease, and how that can help really avoid problems down the line?
Sure. So if both the landlord and the tenant are clear on their rights and obligations from the start, then it prevents disputes down the track. In terms of due diligence, if you have a retail lease, then the landlord's actually going to have to give you some information before you sign the lease that's going to help you understand your rights and obligations. So as soon as you start negotiating a lease, the landlord needs to give you an information brochure that's produced by the Small Business Commissioner and a lease without particulars. And by particulars, I mean it doesn't have to say the tenant, the rent, or the term. Then the landlord's going to need to give you a disclosure statement and a lease with particulars, so this final deal. And they need to do this 14 days before you enter into a lease. This disclosure statement is going to cover things such as the premises. You might have a plan, some details of the lettable area, structures, fixtures, plants and equipment provided by the landlord. You're going to have your permitted use, the terms of the lease, refurbishment and alterations, and importantly, outgoings, the costs that you're going to pay, rent and rent adjustments. Now, it's not unusual to get a call from a client saying that a landlord or its agent wants a lease signed today, and if you don't, they're going to lease to someone else. Besides it not being a great way to start the relationship, there's actually some consequences to this behaviour, and the lease might not commence until 14 days after these things are given. And if there's no disclosure statement before entering the lease, the big consequences here is the tenant may have a right to terminate and not have to pay rent for the period of time before they're provided that disclosure statement. So a big deal if you don't actually give those disclosures or understand what you're entering into at the start of the lease.
Ben or Jamie, have you had any experiences with that? Any thoughts? Have you, any tips, I suppose, if you've ran into a problem down the line that you wish that you dealt with earlier, or that you've dealt with earlier and you're glad that you did?
I'm going to jump in and say, as a tenant representative, I love it when a landlord doesn't provide a disclosure statement. It can be handy. You never know when, you need up your sleeve the fact that they've not fulfilled their obligations. But I think certainly, to touch on what you said, Sarah, around that pressure to sign the lease quickly, particularly with a large landlord, is one of the things that we always try and do is in the initial heads of agreement document, which I know we haven't touched on much yet, but I'm sure we'll get to, is ensuring that you've got an exclusive dealing period in there so that both parties have less time pressure and a greater ability to review and negotiate all of the terms fairly without that threat of we're going to give it to someone else. It's always very helpful.
Yeah, I think just an add-on there. I think as an owner myself, I think it's just critical, and it's scary how many people don't do this, but just to know every piece of that lease, know your lessor works, know exactly what you're entitled to, because when it does come to hitting like boots on ground, and these malls, there's a lot of players, there's development teams, there's leasing teams, and no one really reads the black and white. So they're saying, oh, no, that's not on us, but actually it is. So I think it's just as an owner or someone entering into these big agreements, you really got to know your T's and C's and what you signed up to, and really sort of make it personal. It's a 10-year, for me, it's a 10-year deal. So you've got to know every in and out of that deal, I think, personally.
I love that, Ben. It's like you're speaking for me.
Yeah.
Know your deal, know your lease.
Yeah.
Please read it. And ask all the questions of your professional advisors. You might have a lawyer, you might have someone like Jamie. Ask the questions, understand your deal. Like 10 years is a really long time. You need to know what you're getting into.
I think the bright lights of owning a shop can be very quickly overshadowed in a poor deal.
Definitely.
So as Jamie touched on, let's assume that we have found the perfect premises. We're entering into this new relationship, and we've worked out some things that we want to include in the lease. Would anyone like to talk about the ways that we do document that initial agreement? Whether that's a heads of agreement or some other term sheet. Jamie, how are you advising your clients here?
The thing that we always start with is that typically what the landlord will or their agent will give you is a 1 or a 2, maybe 3-page document with initial terms that you're signing on to. Our preference is always to get as much on the table as early as possible, because once you've signed that initial term sheet, whilst usually it's not a binding contract, and you should always make sure it's not a binding contract, but even if it's non-binding, you're still, morally or ethically kind of committed to the deal unless something, very unusual pops up later down the track in the lease. But so I think you've got the most possible negotiating power before you put your signature on anything. So our heads of agreement is always more like a 10 to 15-page document, because we do, like you said earlier, we want to get as much out on the table as early as possible. We want to talk about everything that's important to our client and make sure that there's no surprises down the track.
Sarah, do you have anything to add on this? I see you nodding.
Yeah, no, I completely agree. One of my pet peeves is when you get a one-pager that doesn't have any detail in it, and what's not included in there is those curly big ticket items, and they come out later as a surprise, and you might be so far down the deal, spend all this money collecting your data, negotiating, and then the deal will be off the table because of 1 or 2 things. There's a couple of ways to document the deal. Jamie mentioned, the heads of agreement first. Some of the legal things that I think you should think about here are binding or non-binding. I also hate binding heads of agreements. The other one I hate is, agreeing to the landlord's standard form lease when you haven't seen the lease. You've got zero idea what's in there. Make sure you know what you're signing up to. Does your deal need board approval? There's some big tenants that have to have numerous board meetings before they can agree to lease in Australia. So that's one you might want to include. And just remember the heads of agreement won't include all the lease terms. So you don't want to be able to, you want to reserve that right to negotiate the terms of the lease later. Again, I'm going to harp on about this landlord standard lease because it seems to happen all the time. You'll go to your lawyer, your tenant representative, and you'll have signed something that you don't understand or know what you're actually signing up to. The other thing that might happen at this stage is you might be in a position where you can start negotiating the lease itself. The landlord might have already prepared a draft lease and you can go straight to the terms of that lease. This might save you a little bit of time. It might not. You're going to be negotiating on one document rather than two, being the heads of agreement and then the lease. And it's also a good way to see everything that you're in for straight up. So really knowing the situation, whether you're going to get that heads done, spend the time knowing what the deal is and read the lease first before you sign anything.
Yep. So I suppose another one for you, Sarah, once you make a start with negotiation, how do you go about that? What are some of the common terms that you see when negotiating? And I suppose just practically what do people need to be aware of during that phase of the process?
Sure. So I might just take a step back and talk about what we're meaning by a retail lease, because this is the first thing you need to know before you start negotiating, I think, because this is really going to affect how you negotiate, what terms you want in the lease, what variations need to be made to the deal that's been put on paper. And it's not really about choosing whether you're going to have a retail lease or not. It's whether the retail legislation applies to your lease. And it doesn't actually matter what it's called, whether it's called a commercial lease, an industrial lease, a warehouse lease, a license or something else. If the legislation applies, then the Retail Leases Act will apply. So the reason that this is important is that there's going to be some rights and obligations and things that a landlord and tenant have to do that are written into the lease document, whether or not it says it expressly in the lease. So in Victoria, premises that are used wholly or predominantly for the sale or hire of goods by retail or the retail provision of services, or a business that the minister determines are retail premises, the Act is going to apply. And what I like to do here is start with the assumption that the Act does apply and try and knock out all the criteria. So perhaps if we start with what's not a retail lease, not residential premises, not a lease for less than a year, not if a tenant is a listed company or a subsidiary of a listed company. Those occupancy costs, which is rent and outgoings, they can't exceed $1 million per annum. Retail services is a big one people get caught out with. So if you're offering retail services and they're not located entirely on any one of the first 3 stories of a building, the Act won't apply. Then we've got barristers' chambers, leases that are 15 years plus, market land, community or charitable purposes, farming or agricultural. So I'll just touch on why this is important and some of the things to think about when negotiating. One of the big differences is costs. So landlords can't recover land tax. They can't charge for that lease preparation. In some circumstances, the landlord needs to pay tenant compensation, including for interference, inhibiting access of flow of customers. and capital costs aren't recoverable by the landlord. Then adding to that, the landlord also has some minimum repair and maintenance obligations. And the landlord's going to have to keep the premises in a consistent condition, and that's a condition of the premises when the lease was first entered into, of the structures, fixtures, plants, equipment, appliances, which is a big one. So that's probably one of the biggest negotiating pieces, I'd say. Understand what the landlord's providing and understand those rights and obligations associated with those things. Then if we want to talk about some extra added tenant protections, there's an entitlement to a 5-year term. There's protections for tenants around unconscionable conduct or misleading and deceptive conduct. And also the landlord can't unreasonably refuse the assignment of a lease, or they might also have a cooling off period after exercising an option. So I think that's the best place to start, just determining if it's a retail lease, and if it is, understanding those rights and obligations of the parties and really building that into your negotiations so you know exactly where you stand.
Yeah, great. Ben and Jamie, do you have any stories to share around the things that have popped up unexpectedly during negotiations as well, that you think our audience need to be thinking about during this stage of the lease life cycle?
Yeah, I think, to be honest, I'd say the really sticky ones in big retail boxes, like I'm probably considered a decent or big box on a retail shop. So you probably say there's probably less than 10 really sticky ones that really can break the deal. And I think with what we did with Sarah, actually in the letter of offer, really put it on the table up front early, relocation, demolition, bank guarantees, personal guarantees, like just to name a few. And I think if you are up front with those, just say handful of items, it can make the deal and the heads of agreement be pretty seamless after that. And then obviously all the annexures at the back that you get added on as we get going. But I think up front, like Sarah said before, really get those sticky ones on the table. Each landlord, like all the big landlords, they're very specific on those sticky ones and how they will attack each one with size of client and so forth. So I think getting them on the table early, working that through, and you'll know if the deal's there or not.
Yeah, I think the only thing I'll add on to the back of that is, again, with those larger landlords that have a tendency to try and make you feel like it is a stock standard lease. It's like when you go and get a mobile phone contract, you don't get to negotiate that. And I think that bigger institutional retail landlords certainly take that same approach, particularly with smaller retailers. But remembering that absolutely everything at every stage is negotiable and guaranteed, they have changed that clause for someone, is a really handy thing to have up your sleeve.
That's a really interesting point. It reminds me of a story of we were negotiating with one of these big shopping centre landlords, and because we've got a few clients in that space, there was this one clause that they were sticking on, and they were saying, "Look, we never negotiate on this. Like, that's it, we're stuck." And I was able to say, "Look, I know you do, because there's X, Y, and Z." Lease we've done with the same landlord, same shopping centre. Everything is up for negotiation, and take your best game with you, put forward what you want, and really try and negotiate that in, because you're going to be locked in. And if you're leasing a premises and they don't agree to what you really need, maybe that's not the right premises for you.
Yeah, Ben, the fit out required for Superpark is pretty extraordinary. I think we're actually going to pop up a few photos so that our viewers can have a look just how unique it is. Perhaps you could share just a little bit about Superpark and what the fit out requires, and any tips and traps for the viewers to consider during that fit out phase.
I think that, to be honest, that in terms of the lease agreement and the fit out works for Superpark, the lessor works are very critical for us. quite a big dip in the ocean in terms of CapEx. So any sort of assistance from usually the spaces I'm going to are part of the development or redevelopment of a centre. So it's our best chance to work with the development team, either use existing, I'd say the big ticket items where the money's spent is using existing mechanical systems, retrofitting roof spaces for some of the activities I have, fire systems, and usually making sure that because the example of High Point, it was 3 shops when I took it over. So really stripping back all the previous tenants' cabling, redundant systems and so forth. So it is a clean tenancy for myself. And also probably the other big ticket item is, I think at High Point we're about a 65 metre glass line. So working with the landlord to retrofit the existing glass frontage to work with that, because obviously huge money in mechanical, glass, electrical, fire. So also probably a tip there is making sure any tenant that enters in an agreement with a landlord, one of the big landlords, just be upfront on agreed rates with their contractors, so fire contractors, electrical contractors, because once you sign, they've got you. Make sure you've sort of covered that off, because it all seems well and good. We're going to work together. We're going to retrofit some fire sprinklers into the rooms from the existing system, but that comes at a large cost, and you can only use one vendor. So probably just a tip there. I think making sure you really go hard at the lessor works, and like I think touched on before, just everything's negotiable. Yeah, maybe they haven't done it for someone else, but they'll do it. If they really want the deal, they will make it work. There's a lot of money to be saved in the CapEx in the black and white.
Yeah, I'm going to jump on the end of that too, because I think it's worth. What a lot of people, when they're starting out with a retail lease, don't realise is that you are always better off as a tenant to split out lessor works from incentive. That typically a landlord will offer you an incentive, depending on where you are and what the market is doing. It might be anywhere from sort of 5 or 10% up to 40 or 50%, and depending on how much they want you. But ensuring that you carve out those lessor works, which are typically things like Ben mentioned, it's the fire services, it's mechanical, it's all of the landlord's capital infrastructure costs that they can depreciate, that should be paid for separate to your incentive, so that if those costs blow out when the landlord goes to undertake those works, they're not clawing it out of the money that they've agreed to give you as an incentive for taking the lease.
Some other things to think about is, what's the landlord going to contribute, how that's dealt with in the deal, and also who owns the fit out at the end of the day and who has those repair and maintenance obligations. That's a big one to be aware of. If it's a retail lease, the landlord's going to have some additional obligations to repair and maintain the things that it owns. Just be very mindful when you're negotiating the deal. And like Jamie said, you don't want the money coming out of any incentive deed. You do want to keep that separate. So, and if they want you enough, like Ben said, they will agree to it. So a few good tips there.
Yeah, great tips. I guess this brings us to the lease itself. So let's assume that we've negotiated the lease, we've documented the agreement. I guess when will the lease start, Sarah, and what are some of the things that we need to be aware of at that time?
A lease will start on an agreed date or when you meet certain criteria set out in the lease. There's also a few triggers in the Retail Leases Act that you want to make sure you don't intentionally start the clock or start the time. So that can happen when you take possession of the lease, you start paying rent, or you and the landlord sign the lease. So my big tip here is don't do any of these things unless you're happy with the lease. So sometimes the start of the lease and the date you start paying rent will be linked with the date the premises are handed over to you after the landlord has done certain works at the premises. So make sure you don't accept handover until you are happy that the landlord has done what has been agreed.
Great. And I guess a big one then is going to be the tenants, the rent that they pay under the lease flowing from that. So can anyone talk about what usually happens to the rent payments during the lease?
They come out of the bank account. To be honest, we get a monthly invoice. I know every deal's different, but mine's a gross deal, so outgoings included. And then I think probably on the lease, probably back to the start. I think what might surprise people is a little bit of negotiation at the start for the incremental increases per annum would be handy, because one year you're paying X and then next the year ticks over and you're like, what happened? So I think probably people don't pay enough attention on that, and the bill comes in the second year round and they're a bit surprised.
Yeah, and that's one of the things with fixed percentage increases as well. Like Ben said, just be conscious that a 5% increase annually is going to be a 25% increase over 5 years. So you really need to know what you're paying. Make sure you understand the market. Get advice on what is a reasonable expectation in the market, and the different ways that rent can be reviewed. So it's usually annually. Like I mentioned, it can be a fixed percentage, it can be a CPI increase, it can be a market review, which is what the market's demanding at a particular time. And turnover rent is also an interesting one. And this is where you usually pay a base rent plus a certain percentage of what a tenant makes of the premises. And there's some risk here for both parties. If the shop does well, then the tenant's going to be paying more. If the shop doesn't do well, the tenant will pay less. And I think this one is particularly difficult to get right for retailers that are just entering the Australian market for the first time. You can really get caught out on that one if, again, you don't do your research and have the data to inform these decisions that you're making.
I'll add on to, while we're still talking about rent, one of the things that we often get engaged at a point where someone's in a little bit of dispute with their landlord and they've got caught up in something they don't understand. And your landlord, unless it says it in your lease, is not obligated to give you a tax invoice for your rent. It's the lease is the agreement to pay the rent. And landlords have a tendency to sometimes forget to put those annual increases on, or they might realise 6 months down the track or something, or they do the calculation wrong. You are still required to pay the correct amount, even if you haven't been invoiced or even if you haven't been invoiced the right amount. And that's often something that trips people up when they get a big bill down the track, when someone realises that they've not quite got it right.
And what about payments for outgoings by the tenant? Is there anything that the landlord needs to do in respect of outgoings, or is it the same?
Sarah, I feel like that's a you question. I feel like you could speak very eloquently on estimates and reconciliation.
Good handball. Yeah, I definitely can. So outgoings are the costs that are payable relating to the premises that landlord pays and the tenant reimburses. Things like rates, owner's court fees. During the lease, a landlord needs to provide a tenant with details of the outgoings. And a tenant doesn't have to pay the outgoings except where they're detailed in the lease. So the ways that you find out about your outgoings is, firstly, the landlord needs to give the tenant a disclosure statement that includes estimate of outgoings no later than 14 days before the lease is entered into. Make sure you read the outgoings with a fine-tooth comb and you understand what you're going to be up for during the lease. The landlord also has to give you this estimate of outgoings at least once a month before the start of each leasing year. If they don't do that, the tenant doesn't have to pay outgoings. Landlords often do get caught out on that one as well. And the landlord's going to have to give you audited expenses and provide a statement that lists the outgoings the tenant has to pay for. This statement needs to be given no more than 3 months after the end of the lease. The only exception to that is if you're only required to pay GST, council rates and insurance, and the statement is accompanied by proof of payment or some receipts of what the landlord's actually paid. So multiple times the landlord needs to tell you what the outgoings are. Give you the audited statement, and if they don't do that, there's some big consequences for the landlord being able to recover those costs.
Yeah, probably a question at the start there of the lease, just in terms of what power usage you're roughly going to use, run it in your P&L, because all the landlords obviously they run it on their own meter. So knowing what those costs are, a little bit different to if you were in a factory or residential or some other sort of space. So knowing what their charge rates are would be critical to know what sort of your P&L is going to run at before the lease is signed as well.
And I guess something else that might happen during a lease is that you might want to sell the business as well. So if that occurs, what are some things that our viewers need to know? Jamie, this is probably one that you you can answer.
Yeah, we look after a lot of assignments and business acquisitions, and it's something that, again, back to that difference between a retail lease and a normal commercial lease. Retail leases are amazing in that the landlord largely has to agree to it as long as the incoming purchaser of your business seems capable of fulfilling their obligations under the lease, which is awesome. But certainly there can be a lot of things in there that you don't necessarily think about when you're signing the lease in the first place, but that may come back later on if you do want to sell. A big one is often personal guarantees. That our recommendation is always that you get personal guarantees out of any lease that you sign anywhere. But it often slips back into the lease as an obligation if the lease is assigned to someone else. And that can greatly reduce another business's interest in purchasing that property if they know that that's then something that comes back on the table.
I might just add to that whilst we're talking about guarantees as well. So this is also a bit of a catch for landlords, that if the business is being continued, the previous tenant and the guarantor will be released from any obligations under the lease and won't be obliged to pay the landlord any money going forward if the tenant gives the landlord and the proposed tenant a new disclosure statement. That disclosure statement needs to not contain any false, misleading or material incomplete information. And then if they've also provided the proposed tenant with business records for the last 3 years, then those personal guarantees and obligations of the tenant will drop off. You can't contract out of that, so just be aware of that. And like Jamie said, they might try and put them back in for the incoming tenant. So just be very aware of the deal that you're signing up to and who's paying what and that balance of obligations when you're selling a business.
Are there any other common issues that crop up during a lease before we move on to kind of the end of the life cycle that anyone wants to raise that you've encountered that our viewers should be aware of?
I would say that if you spend enough time prior and you understand your landlord and you understand, I usually say to people, understand the beast that is a retail shopping centre. I think the lease is pretty straightforward. Like once you're in it, and the month I get a tax invoice. I talk to the operations team sort of on a fortnightly, weekly basis. My venue managers do, I think. Once you're in it, and there's been a lot of upfront conversations. Like I've had coffee with the GM of High Point Shopping Centre. I've met the board at GPT, like for example, for our lease there. Like I think the time up front and getting to know the who's who and the stakeholders within these big malls is so critical to make the lease run well.
I might jump in and put a comment at the complete other end of the spectrum, because you do also see, when you're not in a large shopping centre, if you're in a strip mall or in a smaller town or something like that, you may very well be dealing with a landlord who is, just a mom and pop kind of operation. It might be their self-managed super fund, or they inherited it from Nonna, or they're not terribly sophisticated landlords, and they may not have the resources that a larger landlord has. So what that can mean is that in a lease, even though you've been really clear up front, you've got everything agreed that you want to agree, everyone knows who's responsible for air conditioning maintenance and fire safety and all of those, mold, all of those sorts of things, that fundamentally sometimes you get to a point where it's, even though something might be the landlord's responsibility, they're not educated or capable of fulfilling their responsibility, which shouldn't be the problem of the tenant, but fundamentally does become one. And looking at ways to negotiate through those concerns and get the best outcome is, I think, always one of the most interesting things when you're in a lease. And challenging.
Great. All right, so we enter the final stage of the leasing life cycle. So what are, Sarah, some of the ways that a lease can come to an end?
Sure. Look, by the expiry of time. So you've been in there for your 10 years, and your lease is just expiring. You might need to get out early. So you might be able to negotiate ending your lease early by agreement. If that's the case, usually the parties will enter into a deed of surrender and come to a commercial agreement, which might include the tenant, probably will include the tenant paying some money to the landlord as compensation for ending the lease early. The parties usually negotiate what amount this would be. Some landlords might play hardball and want the full cost of the lease to the expiry date of the lease that they otherwise would have received. They might want some reletting fees, as the agent's reletting fees, or to pay rent until they find a new tenant. And it could also be a lot more than that, because the landlord doesn't have to agree to let a tenant out of the lease. Another thing I've seen is if the premises are damaged or destroyed, the lease might end in two ways. Firstly, if the landlord doesn't reasonably consider that the extent of the damage means that they should repair it, or it's impracticable or undesirable to repair, then the landlord or the tenant can terminate. Or the other way is if the tenant gives the landlord notice to repair and the landlord doesn't repair the damage within a reasonable time, then the tenant can then serve a notice, giving 7 days notice to terminate the lease. And lastly, I'll just touch on where no one ever wants to be, and that is if one of the parties breaches the lease, the other party can serve a breach notice. Usually there's a reasonable time to remedy the breach, and if the breach isn't remedied, then there might be a right for the landlord to terminate, re-enter and take possession of the premises, which practically means the tenant will be locked out and won't be able to keep operating their business. So big deal. Obviously, you'd want to negotiate some other options first. No one wants their lease terminated, and no one wants to have to go to the tribunal or court to try and seek re-entry of those premises after you've been locked out.
Ben, over your career, you've no doubt encountered some of these kind of challenging relationships that are coming to an end. Do you have any tips around where there is a dispute at this stage about the best way to approach that?
Yeah, I think just in Southeast Asia, there was some turmoil during COVID in some of the Hong Kong and Bangkok sites, and I think that was quite sticky. The situation did end up that owner of that franchise, doesn't own those franchises anymore. But how that sort of came about I know in unprecedented times, but I think those upfront lease items that Sarah discussed at the start would be critical if you ever got to that point. If you had to exit or you were under sort of pressure to exit. For me personally, I'm in year one of a lease, and I'm hoping that I never have to talk to Sarah about that in the near future.
We get that a lot.
Yeah. So, but yeah, I think one thing I will say, actually, one thing that I did like at the start of my relationship with Sarah was I wanted a lawyer who actually, one, could get me into a lease, but two, get me out of a lease, in terms of making sure if the world tipped over and I had 3-4 sites and I had to back out of them all, how is that possible in the cleanest possible way? So I think understanding that and working with like partners at Law Squared and so forth, stuff happens, like it's never perfect. So I think knowing the way out more than the way in is critical as well.
I'll jump in and say, I think too, being as open and upfront with your landlord as early as possible. If you are facing challenges, whether that's, paying the rent, or if the site is just not working for your business anymore for a number of reasons, that everyone wants it to work. It is in everyone's best interest for the lease to continue to its natural end. So working with them as early as you can to try and find a solution is much better than waiting until you haven't paid the rent, or you haven't opened the doors because you've got no staff, so you're just not trading that week, or whatever it might be. Be upfront and try and find a solution together always results in a better outcome than hoping it will go away.
Yeah, communication is key. It's key here. As soon as you can communicate what your issues are, what's going on at the premises, why you're having trouble, why you can't pay your rent, just tell them, and try and keep it out of a tribunal or a court, because no one's happy when you need to go that far. And I'd really encourage people to try and find a commercial solution first. And it was great to hear those personal stories from you, Ben, and Jamie, some fantastic tips around that as well.
Well, as always, our time has just disappeared. I think that we could keep talking about this for ages, and perhaps we will off air. But I really want to thank each of you for sharing your experiences and insights today. Maybe before we do wrap up, I'll throw to each of you just to share one final practical tip from your experience in retail leasing. This could be a story that stuck with you that you think our audience could learn from, or just a pearl of wisdom. Maybe I'll start with you, Ben.
I'm looking at a few other sites at the moment now, and I think even lessons learned from my first site. I think you're never going to get it perfect at the start, and you've sort of got to operate a business as well to learn sort of the ins and outs of what you could do better the next time round. I think in saying that, though, I think working with, for me personally, working with Sarah, who has done this with multiple businesses across multiple different landlords, helps a lot, because it is tricky. I think if you do go into a lease thinking you do know everything and you're better than these landlords who have a lot of legal power, I think that might be not the wisest choice. I've spoken to other tenants who my mind boggles to think that they want to take these guys to court. But I think understanding really the sticky parts, and Sarah was great with me on that front, in terms of like the bits that really can get you undone in the end. Like, just say someone taps you on the shoulder and there's a relocation or a demolition clause. Like, what, for most tenants, to be honest, what does that actually mean? And what are your rights and what can be done, and so forth. So I think partner with someone. I might give a plug to you at Law Squared. partner with Law Squared and a legal professional, and I think really understand, like I said at the start, understanding the line by line what you actually signed up to is so important. 10 years of your life, you're wedded to this, so I think it's so critical.
Yeah, and I'm sure that the advocates at Franklin Shanks as well would be a great partner as well.
Yeah.
Jamie, what's your hot tip?
We'll chat later, Ben. It's fine.
Yeah, I had to. Sarah invited me here. I had to give a plug there.
Thank you so much. I really do appreciate it, and I really like working with you. And it's one of the things I really enjoy about working in this space is really getting to know the people, the business. I've been involved in a few fights, so I sort of know what's coming. I think some of the things we talked about today, I think if our listeners get on board and take some of these tips from Ben and Jamie, they can really set themselves up for success here. So I might jump in with a tip. And my last tip is it doesn't matter what a document is called. It might say it's a commercial lease, an industrial lease. It might even be called a license. But if it meets that criteria, retail lease, it's a retail lease. I had a mentor who used to say something I've never forgotten. If it looks like a duck and quacks like a duck, it is a duck. Never forgotten that. And the point here is that if it looks like a retail lease, it usually is, which will be of benefit to a tenant, and the landlord then needs to understand that there's going to be some additional obligations and rights that the lease might not say expressly, but will be imported in because of that retail legislation.
Jamie, close us out.
All right, I will. Look, I was going to talk about what Ben talked about, which is, doing your research, understanding everything that you're doing. That's obviously critical. And I think that goes to a point. One thing that we often see is that people push things too far and kill a deal. So my advice is, even though everyone's heard the phrase, if you don't ask, you don't get, sometimes asking means that you definitely don't get. So really understanding what's sensible, what your rights are, what the market is doing, who the landlord is, what's in the deal, will help you negotiate an outcome that suits both parties. As with Ben's lease, you're in it for 10 years. That is a long time to be in a partnership with your landlord, and ensuring that you go about it the right way means that you're going to have a more positive outcome, and you're probably going to then, get a little bit of leeway when you need it. But pushing it too hard, we all think we're great, tough negotiators, but sometimes it can be your undoing too.
Well, yeah, thank you so much. For me, there's been plenty of key takeaways today. I've jotted down a few. So obviously the key one, and we keep touching, on this throughout the full life cycle of the lease, is really about appreciating that distinction between a retail and a commercial lease. We know that in Australia, the legislation that determines that varies state to state. So it's really important to get this right from the outset. And we're actually going to be sharing a checklist for everyone that's attended to help determine the correct type of lease in our follow-up. So keep an eye out for that. And I think, I thought it was so interesting, Ben, using, data increasingly to, get those insights about the market and demographic, and using that to inform the site location, something I wouldn't have even known that you'd be doing. And I think that's really interesting. And then obviously a huge theme today is just about investing the time and effort up front. We've said to start early, because it is that long-term relationship. It's almost like a marriage, not to go into it with rose-colored glasses, and like you said, Ben, make it personal. So getting that documentation right in the first place obviously will be the backbone of your retail operations, and really provides that clear framework for how things are going to be handled, and hopefully have a smooth lease for the duration of it. And I guess also, if you have a broader commercial strategy around your business, just to make sure that your lease kind of is drafted so you're not locked into any terms that are going to come back to bite you later. So, of course, like we've said, we're here at Law Squared. We're here to help with any property-related matters, whether you're kind of securing your first lease or you need to negotiate terms out of one. So we have a full team of property and commercial lawyers that are available to assist, led by our wonderful Sarah. So we're here to help. So please do reach out to Sarah and myself after the webcast. Our details are in the chat. And really, finally, a big thanks to all of our viewers for joining us. I've seen a number of your questions have come through, and I hope we've been able to answer some of those questions along the way. But Sarah and I will collate those and we'll look at them more closely in the coming days and get back to everyone with more detailed answers. So thank you. Thanks, Ben. Thanks, Jamie. Thanks, Sarah. And goodbye for now.